Hello, beautiful people. Mic check, mic check. Don't mind me while I multitask. How y'all doing? Shout out to everybody who's here. Hit the like button. Oh no, that's not what I wanted to do. Tripping. Hope you're doing well. Full disclosure, I am currently stressed the F out. And I can't talk about it, and I can't do anything about it except sit here and wait. I got lipstick on my teeth. So this came up on my email. And I said, perfect distraction. This is exactly what I need. Oh, goodness gracious. So I hope that you are doing well. Thank you for the mic check. Get my little heating pad going. My little granny heating pad. Oh. It is good to see you all. And yes, we have updates. So we have updates. For those of you who may not be aware, Tory Lanez filed a motion in, I believe, the Central District of California, fighting Megan's effort to depose him in the presence of a judge. So he filed a motion opposing that, and we reread it here. It was a horribly written motion with theoretically valid points. Okay. That's how I would describe that. If you're curious, you can go back and check it out at your leisure. But I was waiting, it's been a couple days. I thought this would be a little bit more rapid, but I guess it took a couple days. Nevertheless, Megan has responded. There's one more thing that I need to look at. Make sure I didn't miss any crucial attachments. The rest of this I already have. Fantastic. So we have her objection, and then yes, attached to everything they submitted a bunch of attachments, the majority of which or all of them we've already looked at, just laying out the sequence of events in terms of the court calendar of everything that's happened so far, and for the judge. But of course, the one thing that they attached that we have not seen before is unless I am completely mistaken and I have blanked, which is entirely possible. I am not 100% at my best. I am, yeah. So it's completely possible that I entirely blanked on that. But I don't think we've seen a Daystar Peterson deposition. I leave it to the chat to check me. Maybe we're here for nothing, but I don't think we've seen it. Also, shout out to everybody who has supported the Docket Fund. Please support the Docket Fund. If you can support the Docket Fund directly through Cash App or Venmo, graciously, with much appreciation, please do so as you are able. Anybody remember a Daystar Peterson deposition? I don't remember one. I fully expect it to be that based on the size of the deposition, which is only 56 pages. And I know a lot of you are thinking, oh my God, 56 pages. That's very small for a deposition. So the size of the page number gives the suggestion that he did not give thorough and complete answers, right? Thorough and complete answers require more paper. I don't have the foggiest idea what you're talking about here. I'm trying to remember. I guess it will come back to us, as we look at it. We'll decide together if we have a collective memory of this deposition or not. Nevertheless, the first document that we are going to be starting with is her actual objection. So, yeah, and I can't remember, was it an excerpt? Like, I'm usually, pretty good with memory, but I'm honestly, personally, right now, stressed the whole fuck out. So yeah, this is what we have. This is where we're starting. Let me see, which way do I want to do this? That works. Table of contents, table of authorities, statutes, other authorities. Ooh, lots of federal rules of civil procedure in there. I wish Fateless was here to appreciate the response to the horribly written motion that we read together. Shout out to Fateless and anybody who might be in the replay gang for this one. Shout out to everybody who's watching. Hit the like button. It was so poorly written. Again, horribly written. In theory, valid points on the surface, but this appears, I'm just guessing this is a whole schooling, I'm just guessing this is a whole schooling. Hey, I appreciate it. Oi, 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 oi. Yeah, baby, this is new. This is Megan's objection. That's literally what my email said when I got the alert. Daystar Peterson objection. I was like, okay, I know what this is, but here we go. This proceeding arises as a direct result of Mr. Peterson's deliberate obstruction of 2 deposition attempts, reflecting a calculated contempt for the judicial process and open defiance of 2 federal court orders. The underlying action, Pete v. Cooper, that is Megan Thee Stallion versus Milagro Grams. Milagro's government last name is Cooper. In the Southern District of Florida, was filed October 29, 2024. Y'all, we've been here almost a year covering this together. That's crazy. Okay. The case is about the extensive and persistent defamation by defendant Milagro Cooper of plaintiff Megan Pete, aka Megan Thee Stallion or Miss Pete, and at the behest and command of Daystar Peterson during and after his conviction for shooting Miss Pete in 2020. Defendant Cooper, a social media personality. Oh, they were nice today. They were nice today. has used her social media accounts to spread defamatory statements, deepfake porn videos, and outright lies about Miss Pete as part of a coordinated campaign with Mr. Peterson. Trial in the Florida action is currently set for November 17, less than 6 weeks away. So any further delay in Mr. Peterson's deposition will unduly prejudice Miss Pete, which is Mr. Peterson's interest, or excuse me. Trial in the Florida action is currently set for November 17, less than 6 weeks away. So any further delay in Mr. Peterson's deposition will unduly prejudice Ms. Pete, which is Mr. Peterson's intent. Mr. Peterson has repeatedly expressed his intent to defy the court's deposition process since initially being served in March 2025. He issued a press release through his counsel at Unite the People, stating that he would refuse to testify, and then evaded testimony both at his original deposition and on April 9, 25, and his court-ordered continued deposition on September 15, 25. This motion is Mr. Peterson's latest attempt to evade providing testimony via a belated attempt to acquire a protective order. Mr. Peterson, who is currently serving a 10-year prison sentence in California State Prison for shooting Miss Pete, is a key witness in the Florida action, as he has for years tried to silence Miss Pete through repeated harassment and paid cyber stalking. After a California court ordered him not to talk about Miss Pete, he began using paid surrogates. That reminded me. Remind me. There is an attachment I need to this. It's Milagro Graham's Venmo account information. I saw that on the list and I forgot to grab it. So you'll remind me. When do I want you to remind me? I want you to remind me after this document. Okay. After a California court ordered him, After a California court ordered him not to talk about Miss Pete, he began using paid surrogates, including Defendant Cooper, someone with deep ties to Mr. Peterson and the Peterson family. Defendant Cooper has acted at Mr. Peterson's direction, helping him circumvent multiple protective and gag orders that bar him from speaking publicly or posting about these matters. She has insinuated that she is on Mr. Peterson's payroll and has publicly acknowledged her friendship with Mr. Peterson and his father. The malicious content she posted that give rise to the underlying complaint was done for the benefit of Mr. Peterson. The Florida action seeks to hold Defendant Cooper accountable for defaming and harassing Miss Pete, something done in part because of payments she received from Mr. Peterson's network. Mr. Peterson's motion must be denied, as this belated motion was brought only because his other attempts to evade testimony and ignore court orders have failed. First, Mr. Peterson's motion is untimely pursuant to Federal Rule of Civil Procedure 45 and should be denied on that basis alone. Mr. Peterson's argument must be deemed waived because he had multiple opportunities to raise all of the alleged issues set forth in the present motion from March to August, when the judge issued an order sanctioning him for his conduct at his initial deposition and ordering a continued deposition under court supervision. Second, Mr. Peterson has not met his burden to prove good cause warrants a protective order. He offers only broad objections with no supporting authority. Third, he cannot show undue burden exists to quash the subpoena. Ms. Pete, on the other hand, explains herein why Mr. Peterson's deposition testimony is necessary to complete the record in the Florida action set for trial next month. Finally, Mr. Peterson's argument that this court should alternatively order a written deposition or shift fees to Ms. Pete are meritless. Okay, background is on the Florida action. Evidence to date has shown that Defendant Cooper has deep ties to Mr. Peterson and frequently communicates with Mr. Peterson's family regarding Miss Pete prior to publishing harassing content about her. As the complaint alleges, Defendant Cooper conspired with Mr. Peterson after he was charged with shooting Miss Pete to spread lies about Miss Pete. Payment records reveal that Mr. Peterson's father, a close friend of Defendant Cooper's, frequently made payments to Defendant Cooper, and Defendant Cooper herself has implied she was on Mr. Peterson's payroll. Exhibit B, Zell records. She has countless She has countlessly posted malicious content demeaning Miss Pete in support of Mr. Peterson. Exhibit A is the lawsuit, in case you're wondering. We don't need that. We've already looked at it. Okay, this goes through the sequence of events of discovery so far. Service of Mr. Peterson. Two days before the initial deposition was scheduled, Unite the People CEO issued a press release ahead of Mr. Peterson's deposition stating, "Good luck trying to get Mr. Peterson to testify to anything. It's just not what he does." The original deposition took place April 9. At this deposition, Mr. Hayden is with Unite the People, appeared on behalf of Mr. Peterson. Mr. Peterson's behavior, it's starting to come back to me. At the deposition was obstructive, exactly as he had intended in the 44-minute on the record. Mr. Peterson feigned ignorance regarding the definition of basic words such as discuss and approve, harassed Ms. Pete's counsel about her appearance. I remember this. Interrupted questioning to discuss his answers with Mr. Hayden, and pretended that the video equipment was not working despite prison staff confirming it was functioning properly. Due to this obstructive conduct, Ms. Pete filed a motion seeking an order to show cause for violating Judge Altonaga's rule. Okay, so more history. This was about the contempt order. He was sanctioned for his conduct at the initial deposition, requiring him to sit for another deposition under the supervision of the magistrate, Judge Reed. That's the judge who slapped the shit out of Aiden Ross. Yeah. And granting sanctions. The continued deposition was to be on September 15. He was served. He showed up, obviously. Didn't have a choice. Mr. Peterson's new counsel, Miss Morgan, who herself continued to work at Unite the People until earlier this year. This is the attorney that filed his protective order motion in California. I was saying when we read that document, who is this attorney out of Colorado? She apparently used to work for Unite the People until earlier this year, claimed at the deposition that the Southern District of Florida had no subject matter jurisdiction or personal jurisdiction, and that she did not have time to prepare for the deposition. Oh. Exhibit N. Oh, I didn't see Exhibit N. Exhibit N. Volume 2. I don't need Volume 1. We already looked at Volume 1. I need Volume 2. I apologize. I'm doing the level best that I can right now, and I appreciate you all being here because this is reciprocal. You know what I'm saying? Like, I need this distraction right now, and we also want to learn this information. So I appreciate everybody who's here. Hit the like button. So we need the Zell records and we need Volume 2. We already did look at Volume 1. All of that is now coming back to me, and I apologize for the very loud airplane flying over, if you can hear that. Mr. Peterson also claimed that he was not previously represented at his deposition, despite his prior testimony that Mr. Hayden with Unite the People represented him in April. Instead of providing substantive testimony, Mr. Peterson asked Magistrate Judge Reed what the consequence would be if he left the deposition. When Judge Reed stated that the sanctions for not testifying will be, at the very least, the attorney's fees and costs for all the attorneys who have appeared today, Mr. Peterson replied, "Easy." When other potential consequences, including additional time for incarceration, were mentioned, Mr. Peterson responded, "Hey, listen, I've got jail for 10 years right now. You can do whatever you'd like to do." And mockingly offered, "I'll pay your flight. Don't worry." Neither Miss Morgan nor Mr. Peterson raised any objection to the taking of his deposition on the grounds that his Fifth Amendment right pending appeal of his criminal case would be violated by such a deposition, which is what he argued in his motion for a protective order to not not have to continue. Nor did they seek the relief. They now ask for Mr. Peterson's 11th hour attempt to raise these issues, demonstrates his blatant disregard for the judicial process and his willful strategy to delay and obstruct these proceedings as trial approaches. In sum, counsel for Ms. Pete has attempted the same deposition of Mr. Peterson twice now over the last 6 months in compliance with the federal rules and 2 federal court orders in the Southern District of Florida. Mr. Peterson, in turn, has followed through on his stated intention to evade providing testimony necessary for Ms. Pete to put forth her case, including by filing this latest meritless motion. A protective order should only be issued upon a showing of undue burden. Good cause must exist for a court to grant a motion for protective order. It is very unusual for a court to prohibit the taking of depositions altogether absent extraordinary circumstances, which is what I said when we read his motion. For good cause to exist, the party seeking the protection bears the burden of showing specific prejudice or harm where a result of no protective order is granted. Interesting. Mr. Peterson's new counsel failed to meet and confer prior to bringing the instant motion. Judge Reed's standing order at the Central District of California's local rules require parties to meet and confer prior to bringing any discovery motion. Did I pass jurisdiction? Because one of the questions that we wanted answered, I don't think I did. No, I don't think so. One of the questions that came up that we wanted answered, nope, I haven't. They haven't. Okay. Is this a jurisdiction issue? He argues, he meaning Tory Lanez, argues that it's a jurisdictional issue. And so I'm assuming that they are going to address that in this. Let me get back to where I was. Sorry. Okay, so no meet and confer. Rules out of Florida require meet and confer. Ms. Morgan ignored Ms. Pete counsel's request to meet prior to filing this motion in violation of both courts' rules. When both courts meaning Florida and California. Meet and confer email exchange is Exhibit O. A court may only quash or modify a subpoena if it fails to allow a reasonable time to comply, requires a person to comply beyond the geographical limits specified, requires disclosure of privilege or other protected matter, okay, subjects a person to undue burden, motion should be denied as untimely. Again, he did not bring any of this up in this entire time that these were his actual objections, because you can, during a deposition, raise objections, and he never raised the specific ones that he has now filed a motion for. A non-party, he's not a party to this lawsuit, he's not being sued, right? He's a witness. A non-party may make objections to a subpoena within 14 days after service. It's been 6 months. So there again, this is just going through timeline and pointing out. So his date to object, he had until April 9th. It's October. He did not raise those objections. He actually complied with the subpoena by appearing at his deposition. He was represented by counsel for that deposition and answered questions at that deposition. He never objected on the basis of jurisdiction to his appearance in Volume 1. Okay. Ms. Morgan's arguments at the continued deposition that there is no subject matter jurisdiction or personal jurisdiction over Mr. Peterson in the Southern District of Florida fail. Subject matter jurisdiction concerns the ability for a court to hear a case in controversy. Judge Altonaga found subject matter jurisdiction over the Pete v. Cooper matter existed in the Southern District of Florida. Any argument that no personal jurisdiction exists for the Southern District of Florida to issue a subpoena to Mr. Peterson is wrong. And any personal jurisdiction objection to Judge Altonaga's order is waived due to Mr. Peterson's lack of responses. Case law. His arguments cannot meet his burden of persuasion. He has not established good cause. Broad allegations of harm, unsubstantiated by specific examples or articulated reasoning, do not satisfy the test. Bunch of case law. Courts may consider the following factors. Okay. Mr. Peterson's motion is a string of broad allegations that do not establish good cause to warrant a protective order or quashing of the subpoena. Mr. Peterson appears to argue he is entitled to quash the deposition under the Fifth Amendment and that a protective order should be issued given his pending criminal appeal of his conviction for shooting Miss Pete. However, Mr. Peterson's request for additional safeguards pending the appeal of his criminal case are misguided and unwarranted. A deponent cannot assert the Fifth Amendment to avoid a deposition altogether. You have to invoke it in the deposition. A witness is not exonerated from answering merely because he declares that in doing so he would incriminate himself. His say-so does not of itself establish the hazard of incrimination. It is for the court to say whether his silence is justified and to require him to answer if it clearly appears to the court that he is mistaken. Hence, deposition with the judge there. Shout out to everybody who's watching. Hit the like button. Directly support the docket fund if you are so able to do so. This my favorite spooky season, my birthday month. Link is at the top of the chat. Again, reiterating that he didn't raise this at any of the depositions he attended on this action. This case supports the proposition that Mr. Peterson indeed should testify at deposition. In Keating, a party to a civil proceeding, Charles Keating attempted to stay the civil proceeding due to parallel criminal proceedings related to the same conduct. Ninth Circuit found Keating's argument unpersuasive. That's why they're using that word, where the civil claims were related to the federal charges. It's literally saying the court should not be swayed by this argument. This argument is literally not persuasive. Evidence of defendant Cooper's relationship with the Petersons family do not bear on his criminal proceeding and appeal. They are, however, directly relevant to Ms. Pete's claims against defendant Cooper. Mr. Peterson should be compelled to respond to questions regarding his campaign to harass and defame Ms. Pete with defendant Cooper for any questions that could incriminate him. Mr. Peterson can invoke his Fifth Amendment privilege on a question-by-question basis, the very approach Keating endorses. His rights will be protected at his continued deposition, as it will be conducted under the supervision of Judge Reed, who can determine whether his silence is justified. Mr. Peterson's testimony and accompanying documents are being sought for a legitimate purpose to prove the claims in the complainant that defendant Cooper was in communications with Mr. Peterson and furthered her misconduct pursuant to his request. Ms. Pete cannot obtain information about defendant Cooper, and Mr. Peterson's discussions from anyone else, especially in light of the fact that Miss Cooper has intentionally deleted communications from her devices and spoliated evidence. Moreover, the information sought is not protected by any attorney-client privilege. It pertains to conversations between Defendant Cooper and Mr. Peterson. Mr. Peterson possesses unique firsthand knowledge of his coordination with Defendant Cooper, and his testimony is relevant to establish their coordinated defamatory campaign. Mr. Peterson has failed to demonstrate good cause. Mr. Peterson has failed to demonstrate good cause warrants a protective order over him or any of the testimony he might provide. The court should find that the Ninth Circuit reasoning in Keating applies and deny the request to enter a protective order, as any further delay would greatly prejudice Miss Pete. Undue burden. He doesn't have any fucking undue burden. He doesn't have to go anywhere except down the fucking hall. Starting in 2020 and continuing to the present, Defendant Cooper has used her social media accounts to spread defamatory statements, deepfake porn videos, and outright lies about Miss Pete at the behest and command of Mr. Peterson. As the complaint alleges, Defendant Cooper conspired with Mr. Peterson, wherein Mr. Peterson would arrange for payments so that Defendant Cooper would spread lies about Miss Pete. In fact, Defendant Cooper herself implied that she was on Mr. Peterson's payroll. This material evidence goes directly toward proving Defendant Cooper acted with malice and engaged in intentional infliction of emotional distress by pairing up with the man who assaulted Miss Pete to spread lies about her and harass her. Given the importance of Mr. Pete's deposition to her case, Miss Pete has consistently pressed for his deposition and worked to alleviate any burdens on the witness. The deposition was held over Zoom and in person at the correctional facility where Mr. Peterson is confined. After the second deposition was adjourned, counsel for Miss Pete reached out to Miss Morgan to meet and confer to resolve this issue outside of court in compliance with standing order and Central District of California local rule. Instead, Miss Morgan filed this motion without conferring with Miss Pete's counsel. Yeah, it's probably going to get denied on that, period. He wants her to pay for it and he wants to do it in writing. She says that's ridiculous and shift the cost to Miss Pete. That's ridiculous. Instead, the court should order a continued live deposition under the supervision of Magistrate Judge Reed, as already ordered by Judge Altonaga. Second, Mr. Peterson does not meet his burden to prove that he has suffered significant costs in association with this deposition to justify his request to shift costs to Miss P. Yeah. Mr. Peterson has provided no evidence that he has borne any costs associated for appearing for two depositions while confined in prison. In fact, it is Miss Pete who has bore the cost to depose Mr. Peterson, twice arranging for a court reporter and videographer. Any costs associated with Mr. Pete's repeated depositions are his alone to bear, as demonstrated by Judge Altonaga's order, ordering him to pay costs for his contempt at the initial deposition. For the reasons set forth above, Ms. Pete requests that the court deny Mr. Peterson's motion so that Mr. Peterson can comply with the properly issued subpoena and subsequent court orders. I was like, I just looked back to the filming screen, like, where am I? I'm in the corner. Okay, let me get these other documents. Shout out to everybody who's watching. Hit the like button. Support the docket fund. Let me see. I have a itemized list of what everything is. Let me look at that. B is Zell Records. Exhibit B. Okay, let me download that. And then the other one is the second deposition. Was that N? I didn't see an. Oh, that's why. I didn't keep scrolling. Jesus Christ. They went through from A to O. I only looked at the first page. I was like, okay, I have all this stuff. I didn't scroll to the second page. Again. Thank you for your grace. Okay. Exhibit N. Let me grab that. Oh, yeah, this was shorter than volume 1. Make sure this is the right one. Yes. Well, it doesn't matter. I paid for it, so might as well download it. Okie dokie. Now we're going to come over here. To the good old water marker. Okay, great. Now we can open those documents, see what we got. Zell Records, and my computer is struggling right now. It's like, bitch, you know this is too much. Okay. Close down all the complicated things. All right. Mods, if you could also keep those links in rotation, appreciate you. Shout out to the best mod squad on the internet. Shout out to everybody who's watching. Okay. Oh, I don't see anything. Oh. It's redacted. If you're like, what the fuck is that? Baby, that's the document. So I'm going to zoom in again. I know there's a lot of black, but the tiny little words, but that at least oriented you, right? Sender name. Okay, we got a transaction date, payment ID, sender bank name, sender name. Carlisle Peterson. Carlisle Peterson. Carlisle Peterson. This is 2021. It's just 7 pages. 2022. Remember, she deleted I think it was over 1,000 pieces of information across several things, right? That's why they got the whole spoliation situation, spoliation of evidence. But again, to keep you oriented so you're not just seeing big black blobs. This is I'm imagining impartial, at least, of Milagro Graham's Zell from 2021 to 2022. And then we have Daystar Peterson's second deposition. We'll get to that in just a second. Let's do a quick check-in. How you doing, everybody? How you doing? Shout out to Jazzy becoming a new member. Appreciate you. No, this is what she received. Received. Shout out to everybody who's watching. We got quite a good group of folks. You could say in the chat, where you're watching from if you're so inclined. That's always cool, But if you're just a silent looter, we gonna leave you be. But I hope you're having a good day, and I hope you have hit that good old like button. Baby, this is a distraction for me. Just as much as it may be a distraction for anybody else, this is definitely a distraction for me today. Past couple days have been a roller coaster of freaking emotions. I hope to be able to tell you all about it one day. Okay, so the videographer starts it off. I know it well. We got a lot of people in California watching today. Brooklyn! Virginia! It's that B-Day month. New York. Oh, Canada. I promise you my friends are sick of that because I do it all the time. Hello. Hey, neighbor. What's up? How you doing? How you doing down there? Kentucky, how you doing? How you living? How you live in South Carolina? H-Town? Chi-Town? Thank you. They've got the videographer. They've got the court reporter. Raise your hand. Swear in the witness. Miss Morgan. Well, I would like to formally object before we get started this morning, and I do apologize for the late entry. I know that Mr. Peterson didn't know the exact date and time of this deposition until late on Thursday and got a hold of me as soon as possible. So this only came to fruition for me as of Saturday, and I'm not familiar with this case. I'm not active on social media. I don't follow anyone. So I have to first object due to no 10-day notice requirement, and no time for us to prepare. But I further object because I strongly feel that Mr. Peterson does not have subject matter jurisdiction to compel his testimony today. This is because I think, from what I've been able to put together this weekend, is that we are compelling him through Federal Rule 37B. 37B only applies to parties, and Mr. Peterson is not a party to this case. He was compelled under Rule 45. I wish she'd really give me something to clap about, which sounds like a double entendre, and I'm gonna let y'all have that. But I wish she really would give me something to clap about, and my cheeks on the posterior that my doctor said needs to be bigger for medical purposes. If you're new here, it's a long story. Okay, but that's how we get down here. Some of you are like, oh, it's the prim and proper document reading later, baby. Yes, it is. Oh, did you miss that story? You missed that story time, huh? I'll have to dig it up and clip it. I told that story on a live, but let's stay focused, okay? His lawyer says, "Oh me, oh my. I used to work at Unite the People, but I don't know shit about this." Sure, Jan. I mean Morgan. Sure. We contain multitudes, as full women. You better leave me the fuck alone. I promise you, I'm paraphrasing, okay? I'm paraphrasing. Obviously, that's not exactly how it was said, but it was very specific medical advice. We're just gonna leave it at that. I know a bunch of people are like, wait a second. No, no. We on this deposition here. We on this deposition. And baby, I will not be doing that, okay? I will not be doing that. I will be on my squat game all spooky season long, okay? Okay? Find me in March. Find me in March. Basically, stop folding up your frame. Give it a little something, something. All right. Let's get back to this biscuit head. My opinion of the law is, despite two court orders from a whole ass judge whose opinion matters more. I also found where another non party was also given an order to show cause through the Southern District of California. And that order to show cause was denied because blah, 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 blah. Therefore, I feel that because Mr. Peterson is in men's colony in California, that we need to go to the Northern District of California to compel today's meeting. And I do know that people have flown a long distance to do this. But I don't believe that we are subject matter jurisdiction to go forward today, and that's not waivable. Mr. Sullivan. Okay, just to quickly respond, we do have jurisdiction. This is a continuation of a prior deposition and is pursuant to the court's order. The court has inherent jurisdiction to finish it. And you're free to make a motion here or in Florida. But as you said, everybody's here. There was a lot of logistics. Your objection is noted, and you can make a motion as to what happens with this transcript or anything else, but we're prepared to proceed. Miss Dixon. And I'd also like to add, I'd also like to add that Caesar McDowell was in the same situation as the same situation as Daystar Peterson, in that he was a third party, non-party witness. This order came in at the same time, basically treating him differently. Neither one of them were represented by counsel, and the court at that time stated that Quinn Emanuel needed to have counsel on board for these depositions. All of the people. There was Ryan Stogner, there was Caesar McDowell, and I was told, so I'm in the process of filing a motion to compel Mr. Stogner's deposition in the Central District of California as understanding that it's appropriately done, and that's what the court order was. Somehow the court departed in this particular instance. This is the same situation exactly, because Caesar McDowell had actually appeared, and then he changed his, then they wanted to do a motion to compel, and it was the same exact situation. They wanted to compel him, and the court made an order. And now it's in conflict with this particular deposition taking place. So she writes how she talks. And I won't be doing that to myself. She speaks as badly as she writes. I'm somehow not surprised by this. I mean, some of y'all have seen my writing. You read my book, but you hear my writing when, and the Substacks, shout out to y'all. You do read there. But you hear my writing when I do a scripted video, and then you see me, hear me talk to you live without a script here. I think you can make the correlation between the two being the same person, Consistency was my point. Yep. We'll get to it when we get to it. You can either be patient or you can go somewhere else. It's that simple. Thank you very much. I appreciate you. This woman is ridiculous. Okay. And now it's in conflict with this particular deposition taking place because both of them they did not have counsel on the email chain that we had going back and forth with the judge. Counsel wasn't there, and court had said that they needed to have counsel for the third parties. That was one of the issues. Yeah, despite popular belief, this is the nitty-gritty. Hold on a sec. Pre-trial conference for this lawsuit, Megan Thee Stallion versus Milagro Grams, has been set for October 30th. I just got a docket alert, so I stopped to check and see what it was, and that's what it is. So again, thank you for your patience. We will get back to the document at hand. The details are the details. This is the nitty-gritty. So if you're just waiting for and then he said, and then he said, get the fuck on. Okay. Caesar McDowell was not represented by counsel because Michael Passion no longer worked for Unite the People. Unite the People was not representing Daystar Peterson as well. But at the same time that Michael Hayden left, that left the same situation with both of them. And Crystal Morgan is the appellate attorney, but she was no longer working with Unite the People anymore. So you can't rope her in and say that he was represented by counsel at that time. And my understanding is that the state bar is considering Unite the People because they don't have an attorney right now. So there's no attorney that can represent anyone from Unite the People at this point in time. My understanding is that the state bar is considering Unite the People because they don't have an attorney right now. So there's no attorney that can represent anyone from Unite the People at this point in time. The state bar is considering Unite the People. What does that mean? You don't have the answer. I'm thinking out loud. We're here pursuant to an order signed by Judge Altonaga. We have jurisdiction. There's a lot of people here, and we're really getting now argument on motions that haven't been made yet. So the disposition of this transcript or whatever happens here, you can make your motions, but we have the people. We've flown here, as you said. We did our best from the very beginning of the judge entertaining this to get everybody noticed, and there's a paper trail on that. And if you make a motion, that will all be surfaced. At this point, Your Honor, I'd ask permission to proceed. Ms. Dixon. And, Your Honor, one more thing. I would suggest that Crystal Morgan file an emergency order in the federal court and as an injunction against this, because this is not, the judge doesn't have not just subject matter, but personal jurisdiction over Mr. Daystar Peterson. So this is Milagro Graham's attorney agreeing with Daystar Peterson's attorney. Yeah, let's not do this, right? Because that benefits their client. If Megan Thee Stallion can't get more evidence against their client, that benefits their client. So they are in this deposition saying, yeah, this is not working. So they're arguing over that. And then the court weighs in. Judge, let me see if I can clean this up or clear this up. First of all, what I'm seeing that was filed is document 65. There was a request for sanctions against Mr. Peterson because of the failure to properly respond to questions at the initial deposition. What I see in the docket is the order from the district judge granting the sanctions requested, and the sanctions was to continue the deposition. So the order that I'm seeing, which is in document 104, is not in response to a motion to compel, but what I'm seeing is an order from the district judge stating that the deposition is to be continued, the same deposition on the same subpoena. So I'm seeing a difference between the other case. I'm trying to think of the name of the gentleman you just named. Miss Dixon, Caesar McDowell, yeah, the court. Judge, there was a request to compel his attendance at a deposition, whereas this is just simply, according to Judge Altonaga, a continuation of the original deposition, and the court is asking me to supervise that continuation. Ms. Dixon, Your Honor, I believe Mr. O'Sullivan. If I could just add, Your Honor, Ms. Dixon, I believe that was a 7-hour, Mr. O'Sullivan. Docket 42 is the original order from Judge Altonaga back in February ordering this deposition. Because the witness is in prison, we did have to go through the court. So there's an earlier order from Altonaga as well, setting up the first deposition, and this is the continuation. Miss Dixon, which is Milagro Graham's lawyer. But that means that she met jurisdiction to do that. And so the prior counsel, he has an issue of ineffective assistance. Now, this is Milagro Graham's attorney arguing that Daystar Peterson had ineffective counsel from Unite the People. Milagro does because right now I represent her. She has an issue of ineffective assistance of counsel with that particular counsel simply because they didn't raise jurisdictional limits and they didn't properly respond to, she keeps going back and forth between her and his, respond to his motion to compel because they did not have, he was not represented in this motion to compel once again. So I don't see that that would be relevant for him. He didn't have an attorney at that time, Mr. O'Sullivan. But Rhonda. Oh my God, I wish Fateless was here. It's not bad grammar on official documents. This is a court transcript. They're speaking. This is proper. This is the transcriptionist transcribing everything that they say. I didn't know her name was Rhonda. I'll be perfectly honest with you. He was like, Rhonda. Oh, now you want to play brand new because Crystal's here playing brand new for him. This is just poor oral communication. But Rhonda. Baby, send me a drink. Hit that link at the top of the chat. Oh, God, my nerves have been on a fucking roller coaster the past 24 hours. But Rhonda, you're arguing motions you haven't made and that Crystal hasn't made. Miss Rhonda Dixon. Well, you keep holding me to time frames that I wasn't here. You keep telling me that I should know everything that happened in this case before I got here. Well, you should. It's on the docket. You should read everything when you take on the case. That forehead tattoo MAGA lady just give you some money and you said, okay, I'll do it. You didn't look at the docket. You didn't read every fucking thing on the docket. Baby, ain't that your job? Added. Okay? Added. Shout out to T-Mac for the super sticker. I appreciate you. Back to Miss Rhonda Dixon. So, what is it? Do I not? Or do I, So, yes, I am going to argue something that I'm just finding out about. Yeah, Mr. O'Sullivan, which is Megan Thee Stallion's lawyers. What are we supposed to do? We've been litigating the case the whole way. You come in late and say, I'm going to protect the court. Excuse me, Mr. O'Sullivan. I think the Judge Altonaga, wanted a judge here so that I could make a ruling. And I'd like to go ahead and make that ruling. Miss Dixon, thank you. The court. Here's the difference we have, Miss Dixon and Mr. O'Sullivan. We have a court order saying that the deposition is to be continued, right? And that order was months ago, back in April. And then there's no objection to that order at all. And then we have a notice of deposition that was set. The deposition notice is dated September the 8th. We also have no objection to that deposition order. So we arrive here today, and I get an email saying there is an objection stating that this should have been done under a separate rule. But I think that objection is way too late. She filed this shit anyway. I didn't want to say it when we read Daystar Peterson's, motion, but I think he found the most biscuit head ass lawyer that he could, who's thirsty to be relevant and matter, and has her JD. And she said, I'll do it. She can't write and she can't speak. The court has not traveled under a motion to compel, but is simply continuing the original deposition. And if we'd gotten this objection earlier, perhaps we could have straightened that out earlier. But this is a different situation for Mr. McDowell. So that's my ruling. Miss Morgan, Your Honor, though, I did only receive this on Saturday myself. So, I mean, had I received this earlier, I would have filed the appropriate motions that needed to be filed, but I did not receive it earlier. And I'm not quite sure the court. It's not a reflection on you at all, Miss Morgan. And all I'm saying is there was no objection from anyone on behalf, Miss Morgan. Yes, the court of Mr. Peterson. Did she forget who her client was? He's not your client, ma'am. Ma'am? Rhonda? Daystar Peterson is not your client, Blue. Boo. Milagro. Milagro Gramps. That's your client. And the judge is saying, we received no objection. And this is where she's checking herself. Oh, right. I'm not his lawyer. Of Mr. Peterson. Miss Dixon, Your Honor, that's because he didn't have an attorney to object on his behalf at the time. The court, yes. Miss Morgan, I did have the court. Mr. Hayden, who appeared for him before. Miss Morgan, Mr. Hayden left. The witness, Mr. Hayden was never my attorney. He was never my attorney. I never signed on with Mr. Hayden. I never said that he was my attorney ever. The court, excuse me, Mr. Peterson, do you have an attorney present that's representing you today as far as these proceedings? The witness, at this moment, Crystal, yes. The court, okay, so here's what we're going to do. I appreciate you explaining that, but I'm going to have Miss Morgan speak on your behalf since she's your attorney and she can tell me what your position is. Because if we have too many people speaking, one, that creates the witness. Can I ask you a question, Your Honor? The court. No, I'm afraid you can't. You have an attorney and you can, Miss Morgan, I can ask the question. The witness. Okay, Crystal, what is the penalty for me not doing this deposition today? Miss Morgan, if you chose not to participate, they would sanction you the same as they've sanctioned you before. The witness. But what is the overall if I choose not to do this deposition? Is there a fine? Is there some jail time? What is the Mr. O'Sullivan? There's potential consequences and it's a range. The court has the witness. I would just like to know what those consequences are if that's possible. The court. Miss Morgan is your attorney and I'll allow you to ask her questions. The witness. No, I'm talking. Yeah, I was talking to her, not to disrespect you at all. Miss, Your Honor, the court. I understand. Miss Morgan. Yes. No, Mr. Peterson asked me before this deposition on Saturday if he didn't show up, what would be the fine? What would he be, what would he be looking at as a sanction if, he chose not to participate? And I do think it's a valid question. And I am still searching. I need to know where I find that it's a continuation from the court from the prior order. Bitch is either dumb or playing dumb. Either way, I'm irritated. We all die. Whoop-de-doo. I haven't clipped it yet, but I'm gonna, and it's gonna become a button. What's the scale of punishment here? Do you make me shave all my plugs off? What happens? I'm still searching. I need to know where I find that it's a continuation from the court from the prior order. I'm currently looking for that, and I see notice of 90 days expiring. Oh, this girl. But I do feel that this is a little like, Mr. Peterson just said Mr. Hayden was not his attorney. He literally said in volume 1 of his deposition when they asked him, "This your lawyer sitting next to you?" And he said, "Yes." He did a limited representation for that last deposition. And then the emails that went back and forth this morning that were forwarded to me from Mr. Hayden at the prior counsel that was local in Florida, they both stated that they were not Mr. Peterson's attorneys. We read that. Remember, we read that email. And so although again, I apologize for my late entry, but I can't be held to things that happened prior to my entry of the case. Number 1. And number 2, I do feel that I need, more than just a reassurance that this is coming off as a continuation and that it's the judge just ruled. I'm tripping. Okay, I'm sorry. And that it's a different situation for Mr. McDowell because I just don't see that from the order that I'm looking at. Mr. O'Sullivan. Well, that is what the order reflects. And there was a deposition and Mr. Peterson was here for it. The court. Excuse me, Mr. O'Sullivan. Excuse me. Because Mr. O'Sullivan is about to lose his fucking mind. He's had it with this bullshit. The judge said, "I find based on these docket entries on the docket for the lawsuit, this, and this. I think I need more than just a reassurance. Like a judge isn't in the fucking room right now. A judge is in the room. A judge is in the room." Sorry. He is about to lose his shit because he knows this is biscuit headassery. This is biscuit headassery. Judge said, "Excuse me, Mr. Sullivan. Excuse me." Okay. If you have the docket open, if you could look at docket number 1, docket entry number 104, court reporter 1004, the court 104, ordering, the judge that Mr. Peterson shall pay Plaintiff Megan Pete the reasonable attorney's fees incurred in taking volume 1 of his deposition. The continuation of Mr. Peterson's deposition shall proceed under the supervision of the magistrate judge Lizette Reed. That is ordered on the first day of August 2025. So at that point, the district judge, in response to a motion for order to show cause why Daystar Peterson should not be held in contempt, which is different than compel, it's contempt. The court ordered that Mr. Peterson, the witness, shall pay the reasonable attorney's fees incurred by taking the initial volume 1 of the deposition, and that he shall proceed under the supervision of a magistrate judge for the continuance. I can tell you, in response to your client's question, that if he doesn't appear for deposition, then the California court can essentially do the same, require him to appear for deposition, or allow the Southern District of Florida to do so. Will require him to pay all the reasonable attorney's fees and costs that would be a part of that would flow from that. And then he would still end up taking a deposition. But as for today, I want to make sure, Ms. Morgan, that you understand that it's a continuation, and that's where the wording comes from. Are you able to see Order 104? Ms. Dixon. You didn't have an attorney. Miss Morgan, I'm looking for it right now, Your Honor, the court. Okay, Miss Morgan, I do have my team sending it to me, so they're pulling it for me now as we speak. This background discussion between Attorney Dixon, who represents somebody else, and Daystar Peterson is crazy. The rarest of breeds. Hey, beautiful. Baby. baby. Miss Morgan, I just don't, I mean, throughout the whole instance of this case, it seems to me that Mr. Peterson was very limited in his legal representation. And so regardless, I just don't understand why, why this court has jurisdiction versus, Mr. McDowell, whose jurisdiction lies in the Central District of California. I do feel, like I said, that, it must be Rule 37, not 37A, not 37B, because they're treating Mr. Peterson like he's a party to this case, and he's not a party to this case, the court. Well, there was never a Rule 37 motion filed. I could tell you that in this particular instance. I'm also surprised that you're telling me, Miss Morgan, that he didn't have counsel, because when I look at the transcript from the deposition of Mr. Peterson, I can't make this shit up. Let me apologize. I always tell y'all, don't get ahead of me. And here I am, getting ahead of a whole ass judge. I'm so sorry, Your Honor. I'm so sorry. I should have known you was going to get to it. You was going to get to it. I'm also surprised that you're telling me, Miss Morgan, that he didn't have counsel, because when I look at the transcript from the deposition of Mr. Peterson, Mr. Hayden appears to be representing him. So this is a surprise to me. Let me see if I can pull that up. The court, volume 1 of Mr. Peterson's deposition. Maybe my law clerk can show me that, but I remember seeing that earlier, that Mr. Hayden had appeared on his behalf. Miss Dixon, again, not his lawyer. Your Honor, I don't believe Mr. Hayden was present on that August 1st, that whatever that hearing was, and when the ruling was made. He had already exited from the UTP firm shortly after Caesar McDowell's deposition. Mr. Hayden had exited the firm. Really? Well, this is news. He's still on the website. She's done it. She's gone in this circle 3 times. We are on page 24 of 51. They haven't even asked a question yet. This whole thing, she started it off. As soon as the court reporter and everybody else got done with the technicalities, she was like, off top, objection. And this objection cannot be waived. So that was her attempt right there to stop the deposition. Blue isn't blue. Wednesday isn't Wednesday. My client doesn't know his name. I didn't know about any of this. I'm not on social media, bitch. You're supposed to be on the docket. If I do say so myself. I'm bulletproof. That was a bar. Dixon is for Milagro. Morgan is for Daystar. O'Sullivan is for Megan. Oh, these motherfuckers got some goddamn nerve. Sorry. Mr. Hayden had exited the firm, so neither one had judge. Let me ask you, was he there for Mr. Peterson's? Was he present for Mr. Peterson's deposition? Miss Dixon, I believe he was. You were there. Wait, was she there? Or was she there for the second one? She might not have been there for the first one. She might not have been there for the first one. She was probably there for the second one. Okay. All right. Okay. I believe he was, but he would have been present anyway because he represented Milagro Grams at that time, and that's who he officially represented at that time. He was not representing Mr. Peterson. It's just like, he was representing Milagro Grams. These motherfuckers are playing a whole ass game. Oh no, he wasn't there as Daystar Peterson's lawyer, even though he clearly behaves as Daystar Peterson's lawyer throughout the whole fucking deposition. No, he was there because he would have been entitled to be there because at the time he was also representing Milagro Grams. You see how these biscuit head ass motherfuckers weaponized the law for biscuit head assery bullshit? And this is why I started following this case from the very, very beginning. The moment I saw unite the people in those two places, I said, these people are on some real bullshit. These people are on some real bullshit. I said allegedly the lawyers are in on it before Megan's lawyer said the lawyers are in on it in a court document. Exactly. They are trying to play a legal shell game. He wasn't there representing Daystar Peterson. He was there because he had a right to be there because he represented Milagro. No, motherfucker. We got rid of those meddling kids. We're clear to go. Huh? Mr. O'Sullivan. With all respect, Miss Dixon, we corresponded with the counsel for Mr. Peterson about the order to show cause. We reported his position to the court. Miss Dixon, but that wasn't his attorney, Mr. O'Sullivan. I feel like it's hard for me to respond to you because you're saying you don't know the record and then you're making assertions about what was or wasn't there. There was a lawyer there. There was a lawyer that corresponded with us about this motion. Miss Dixon, no, they did not. You'll find that's not the case, Mr. O'Sullivan. There's a transcript. The court. Well, let me see if I can pull up the email. Earlier today, my law clerk sent me emails in which Mr. Hayden at least was on the email if he didn't actually respond. Let's see. Miss Dixon, Mr. Hayden hasn't been working for the firm for a while, though. He doesn't work for the firm UTP. He quit. Mr. Humphrey. Your Honor, this is Dan Humphrey. I have no idea who Dan Humphrey is. I don't remember this name. The court. I don't know how the court would have been aware of that. Did he file some sort of notice to the court? Miss Morgan. I don't believe Miss Dixon. No, but Miss Morgan. He needed to because he never... I don't believe he needed to because he never entered his appearance with Mr. Peterson formally, and I believe that he did what he needed to do with Mr. Cooper to withdraw, but he would not have withdrawn from Mr. Peterson because he never formally entered. Mr. Humphrey, Your Honor, Mr. O'Sullivan. If I could, Danny, before you start, if I could just tell you, Judge, we do have a hard cutoff here this afternoon here in the prison and a lot of people here. So anyway, I think we're going to be pressed for time if we argue all the motions now. I just want to make the court aware that we do have this time pressure that we're using now, which could be used for testimony, and we could have these motions argued later. Miss Dixon. Well, Your Honor, the court. Thank you, Mr. O'Sullivan. Miss Dixon. He never had counsel on any of those emails where this particular, even the scheduling, according to what I'm understanding, he didn't get the notice until Thursday that this deposition was to take place today. Miss Morgan. Exactly. Aha. Aha, aha, aha. The court. Yeah, I knew I had read that earlier this morning. So, Mr. Hayden, is representing that he's the attorney and he's on the emails. The witness: I never signed any agreement with Miss Dixon. Well, he never signed agreement with Mr. This is what Mr. Daystar is telling me right now, is that he never signed anything with him, and that at the time he actually worked for Milagro Grams, and I now took over that position. So the court: well, he did represent that he was the attorney. As I said, he was ordered to go forward today by the district court, and that's the court rulings. Mr. O'Sullivan: thank you, Your Honor. Miss Dixon: Your Honor. The witness: Crystal, can you please? Miss Dixon: Your Honor. The witness: just again, ask the same question I was asking before. What is the fine and what is the consequence? Miss Morgan: yes. What is the fine if we don't go forward today? We're not prepared. We would like to go formally object before we give any testimony. So we would like to find out what the sanction is today and go to the appropriate court and file our injunction. The court: okay. So as I understand it, the sanction will be, at the very least, the attorney's fees and costs for all the attorneys who have appeared today. The witness: easy. The court: the attorney's fees and costs for everything dealing with Volume 1. I see that there are requests for additional time incarceration as a result of this. Did I see that on Judge Mr. O'Sullivan? It's certainly within the contempt power. I mean, there's an escalating set of consequences that would cause you to choose testifying at some point. The witness: hey, listen, I've got jail for 10 years right now. You can do whatever you'd like to do. The court: so counsel, Miss Morgan, if you could advise your client with respect to all the different consequences that flow from failing to appear at a deposition. I'm sure you're as aware of all of those consequences as the court is. Miss Morgan: well, yes, Your Honor. Of course, I'm a lawyer. Right now, without knowing whether or not subject matter jurisdiction lies in the Southern District of Florida, I'm not sure if the sanctions would be void or not. At the end of the day, of course, they'll be able to charge you reasonable attorney's fees, and I'm sure they'll ask for their costs to travel to this deposition today. But I'm not aware of any, further sanctions that would be appropriate, as Mr. Peterson, this is the continuation of the first one. Why did she just say this is the continuation of the first one, if this whole time she's been saying it's something different? Hello, beautiful. Yes, he is. I don't think she was supposed to say that. So if this is a continuation of the first one, I'm not even positive that Mr. Peterson's been held in contempt correctly or not. I still have to do a little bit of research. Oh, Jesus. So as far as what actual sanctions can be held here, I'm not sure if adding prison time would be possible or not. I don't believe so, because I don't believe his conduct has risen to that level. Because on the one hand, we can't say that his conduct has risen to that level to add an additional jail time if this is still a continuance of the first deposition. If this is a second deposition, then perhaps that would be an appropriate sanction. Miss Dixon: Your Honor, I have a question. The court: are you familiar with his first volume? Have you read the deposition of Volume 1? Miss Morgan: no, Your Honor, I have not. I just received this on Saturday. The court: okay. Miss Morgan: so no, I have not read. That's why I said at the beginning, I'm not familiar with this case. I mean, I'm not prepared. I wish I was, but it's a voluminous case. I haven't been following it on social media or anything, so I can't really tell you even what the substance is at this point, and I apologize for that. But I've been focused on Mr. Peterson's appellate efforts. Just a month ago, we did oral arguments. The court: okay, all right. So what is the result of your conferral with your client, and what are you going to do today? Miss Morgan: we're going to file the appropriate objections in the federal court before we give testimony and find out if and when that this court can compel Mr. Peterson, or if we need to go to, California to compel his testimony. The court: okay. The way he told her 1,000 times it's not a motion to compel. It's a continuation. She said, no, it's not. The judge is like, okay. At this point, okay. Because we have gone around and around and around and around in this circle, literally parsing and defining fucking words, literally looking at the court docket, literally looking at the transcript where he is asked, is this your lawyer? And he's like, yep. Where Mr. Hayden says, I'm here for this man to help him with this deposition. Where he then turns to Mr. Hayden, asks him questions throughout the deposition. Mr. Hayden answers him because that's his fucking lawyer. This is insulting. This is totally fucking insulting. I haven't been following the case on social media. Again, docket. I've been busy with his appeal. Okay. You've been busy with his appeal. You had no knowledge that this was going on? No knowledge at all. And then you turn around and argue in a motion to quash or give a protective order that this affects the appeal. Well, if it affected the appeal, wouldn't you have known about it working on his appeal? Huh? Rhetorical question. Fuck. The court. Okay. It could be that on Saturday was the first official time that he contacted her to specifically expressly represent him in this situation. We don't know, but Saturday is real specific to her. So, Mr. O'Sullivan, Your Honor, so we'd like to ask our questions, and the witness will do with his counsel what he chooses to do, but we are all here. We did spend a lot of money, and we're set up to go. Ms. Dixon, no. Mr. O'Sullivan, I think you've ruled on the objection, right? The court. You may proceed by asking your question. Mr. O'Sullivan, yes, the court, so that we can make a record. Mr. O'Sullivan, all right, well, we are on the record. The court reporter, we're on the record. There are separate causes of action. One is his appeal for shooting. This is a civil case for harassment. Ms. Dixon said no. Mr. O'Sullivan said, I think you've ruled on the objection, right? The court, you may proceed. These motherfuckers are tripping. This is my job. Thank you, though. You're welcome, beautiful. Yes, it is. Fast and Furious. We are on the record. So, Mr. Peterson, I'm going to make a record. The witness. Excuse me. 1 second, sir. Crystal, Miss Morgan. Yes. The witness. Just again, out of curiosity. I mean, it seems to be I just seem to be a little bit lost on what the answer was to me not participating in this deposition. So if there's no immediate thing you're going to do, Mr. O'Sullivan, consequence, I'm going to ask you questions. You'll either answer or not answer. The witness, before, with respect for, sir, before that, Mr. O'Sullivan, they have fucking had it with this dude. The witness, if there's no immediate, sort of thing you're going to tell me to do right now, or there's no immediate consequence, I'm going to leave. I'm done here. So that's what I'm trying to figure out. What is I need to pay your flight or something? Mr. O'Sullivan, I'm not your lawyer. But I can tell you that the witness, the fees though, Mr. O'Sullivan, the point of the judge's role is to compel you to testify. The witness, I understand that. Miss Dixon, can't compel. Oh my God. These people are horrible. I'm sorry. I just had to get that out of my body. Mr. O'Sullivan. And so, sir, Miss Dixon, no jurisdiction. Mr. O'Sullivan. And so, at least in my experience, there are ranges of consequences, and they could be anything up to incarceration for civil contempt. The witness. And while I respect that, I'm just trying to understand what the exact consequence of this day, this session, this proceeding is going to be. Can I get that? Miss Morgan. That's why I said I'm not sure. I don't know if they have enough to go after civil contempt. I mean, if it's a continuation of the first, the first subpoena, then I argue that they kind of can't have their cake and eat it too. So I don't feel that this is enough for them to go after the witness. I don't understand. Miss Morgan, contempt to add more jail time if it's the same deposition. I mean, if this was a second deposition, that would be a different story. But I feel right now that we need California to kind of come in and tell us where jurisdiction lies. But they're saying that, this is a continuation. And so if you walk, I can tell you definitely that they will have enough to be able, charge the attorney's fees. They're already doing that, but you ain't read the docket. The witness. Their fees are, it's fine, Miss Morgan, and costs of the process, the witness. Whatever they charge, that's fine with me. The court. In addition to attorney's fees, I want to make sure, Miss Morgan, that you tell your client that he could also face fines and jail time. Miss Morgan. Yes, well, that's what I said. It's costs. Yeah, that's a possibility, but I'm not positive yet because I'm not very sure. No, there's a difference between fines and costs. Costs are the costs incurred by Megan's team to do all this shit. That's how much money Megan has to spend for this deposition. She's got to pay her lawyers. The lawyers have to fly out, room and board. She's got to pay for the videographer. She's got to pay for the court reporter. She has to pay all that shit. Fines come from the court. That is a separate amount of money, up to the determination of the judge. So the judge is trying to point out, like, there's additional things, and she's saying, well, that's what I said. It's costs. No. Rhonda. He's going to slam the laptop shut type shit. That's where they want everybody, including the judge. They want everybody lost and confused about this. We are on page 34 of 51. They still have not asked him a question on the record. I'm sure they'll ask for it now, and so we'll have to, think of that and object this afternoon in California. Miss Dixon, Your Honor, just one question. How long was his previous deposition? I wasn't there. Mr. O'Sullivan, I understand, but that can't be weaponized in this case where you people say you haven't. Miss Dixon, I can't. You're weaponizing, Mr. O'Sullivan. Read the record, and then you say, Miss Dixon, I want to ask the question. The witness, you people is crazy. You know what's crazy? Shooting a woman. You know what else is crazy? Miss Dixon cooning. Miss Dixon, I know that's racist. The court, inaudible. The court reporter, I'm sorry, wait, Your Honor, I can't hear you. Will you repeat what you said? Because there's conversations going on over there. The court, exactly. That's why I need for everyone to shut the fuck up. That's not what he said. That's why I need for everyone to listen for a few minutes. Either we are having today's deposition or we are not. Either your client is going to go forward, Miss Morgan, or he is not. And I'd like for Mr. O'Sullivan to make a record by getting to ask his questions, and we can start or we can start to get the responses and we'll have a record of what happened at this deposition. Mr. O'Sullivan, thank you, Your Honor. Miss Morgan, so they'll ask you a question, Daystar, and I'll just respond with our objections so they can get it on the record. Question. Good morning, Mr. Peterson. My first question is easy. Have you given sworn testimony before? Have you testified in court ever? Miss Morgan, Your Honor, we object. We don't feel that this court has subject matter jurisdiction at this time to compel Mr. Peterson's testimony. We did not receive a 10-day notice prior to this deposition. And as new counsel, I have not had time to prepare for this case. The court. Okay. And as far as the ruling from the court, the deposition has been continued to this date by Judge Altonaga. The continuation happened months ago. At that time, she ordered the continuation of the deposition, and sanctions can be attached for Mr. Peterson's failure to continue with this deposition. Those sanctions that are accorded by the rules can be fines, jail time, attorney's fees, and costs incurred. I can also tell you that even if you do contact the California courts, we'll end up right back here again because the court will authorize this deposition, the subpoena issued by this court. My only concern, what would make more sense right now, is if you are not prepared to go forward, Miss Morgan, that you at least reschedule the date at this point in time, because the deposition will occur one way or the other. Do you have a date on which you intend to reset this deposition, so at least we can note that you intend to go forward in good faith? Miss Morgan, if we needed to, it wasn't offered to me, and that would be actually very helpful. So I could have more than, approximately 24 hours to read on such a, voluminous case. The court. I will point out for the record that the notice I have was dated for September 8th. So it was at least from the 8th to the 15th, 7 days notice. Miss Dixon, but, Your Honor, he didn't have any way to get that notice. He's incarcerated. Mr. O'Sullivan, there's a record of the service. Miss Dixon, he didn't have it, and he wasn't represented by counsel. Miss Morgan, Mr. Peterson reached out to me as soon as possible from the time he received the notice, with the limitations of him being incarcerated. The court, can I ask you whom he received the notice from? Miss Morgan, I don't know. Mr. O'Sullivan, he was served in prison, Your Honor. Miss Morgan, Mr. Peterson, who gave you the notice? The witness, somebody who works here. I wasn't served. Like, they didn't give it to me like I was being served. By the way, it wasn't one of those either. It was like someone who should not have been giving me the paper is who gave me the paper. But I don't want to talk bad about the jail, so I'll just leave it under wraps. Mr. O'Sullivan, I believe we filed the formal process for service on an inmate. The witness, well, sadly, in CCR, things don't go the way you plan them all the time. The court, can you ask your client, Miss Morgan, when he received the notice and whom he received it from? Miss Morgan, he doesn't know whom he received it from, and I was told on Saturday that Mr. Peterson received it late Thursday. 7 days. The witness, it might have even been Friday. It was one of those days. It was either Thursday or Friday. Judge, okay. The witness, and I haven't even had the adequate time to prepare myself for this. This is 3 days ago. I call bullshit. This is a continuation. You should have been prepared for this deposition 6 months ago. How the fuck you think I feel? I hope one of you looters out there is gonna give me some comfort food lunch today, okay? Gift me some comfort food lunch, because this is aggravating as fuck. And this was supposed to be a distraction for me for some aggravating shit. Oh my God. I haven't even had time to adequately prepare myself for this. This is 3 days ago. Mr. O'Sullivan, Your Honor, the court. Miss Morgan, when would you like to reset the deposition for? What dates are you available? I can be flexible, Your Honor. Due to the importance of this, we can do the beginning of October. I am wide open to the beginning of October. The court, I need exact dates. Miss Morgan, what about October 8th? That's tomorrow. Miss Dixon, you know what, Your Honor? I don't have my calendar, Mr. O'Sullivan, nor do I. Miss Dixon, right now, because we are not allowed to have our phones. So, Mr. O'Sullivan, and I appreciate what you're trying to do, Your Honor. I mean, we do have a strong objection. We're all here. We traveled, everyone else prepared. And even the subpoena or the notice of this deposition was the culmination of an order to show cause process that went on for months. And all those prior papers were also served on Mr. Peterson. Miss Dixon, no, they weren't. Mr. O'Sullivan, there's a record of it, Rhonda. Maybe Rhonda is Miss Dixon. I thought she was somebody else. Anyway, there's a record of it, Rhonda. Miss Dixon, no, there isn't. I mean, it was sent by email to us, the court. No point in arguing that. The record will stand for itself, and that's what will happen. You all have the emails that have Mr. Hayden on them. Miss Morgan, yes, but Rhonda is Dixon. I'm sorry, I'm getting confused. Crystal is Morgan. Okay, yes, those emails from this morning, the court. No, I have an email from Mr. Hayden saying he has no objection to the continuation of this, Miss Morgan. Actually, what he said in those emails this morning was that he was not representing Mr. Peterson, the court. Right. But I have emails where he said, and this would be some months ago, where he said that he had no objection, no opposition. I remember, I read that. He actually said that it was a good idea to a continued deposition. Are you not aware of those emails, Miss Morgan? Miss Morgan, no, Your Honor. The court, would it make a difference if we pulled up those emails and sent them to you right now? The witness, I'm not aware of those emails either. And furthermore, I never authorized him to do any of that. The court, okay, Miss Morgan, that's what I was going to say. The court. So the court will note that you were aware of them. Miss Morgan, it wouldn't matter because he wasn't his attorney officially, Your Honor. So, I mean, if he continued on behalf of someone that wasn't his client, that wouldn't be appropriate. The court, okay, no, he was his attorney at the time. Let me see if I can pull up those emails. And then I think he's talking to somebody on his staff, Malind. The witness, does she have some sort of proof of being my attorney? The clerk, yes, give me 1 second. The witness, where's the proof? The court, I want to make sure, Miss Morgan, that you have everything, Miss Dixon. In the deposition transcript, the court. The court reporter, I can't hear the judge, Your Honor. I'm sorry, they're speaking over here and I can't hear you. This is the court reporter, Your Honor. They're speaking over here and I can't hear you. Would you repeat what you said, please? The court, yes. No, I was speaking to Miss Morgan, counsel for Mr. Peterson. I want to make sure that you have the full information so that you can advise your client and have the emails on which Mr. Hayden did not oppose this continuation. Miss Morgan, thank you. The court. And the deposition where he stated that he did represent him. So I'm going to let my law clerk pull those up so I can forward them to you. Do you have an email? I did receive the emails this morning. Mike was very clear that he was doing a limited appearance. So, I mean, yes, he was doing a limited appearance at that time. But Miss Dixon is correct. Michael Hayden has not worked for Unite the People in approximately 6 weeks now. Interesting. Noted. Never the fucking less. He was the attorney of record on this deposition which has been continued. So it's the same fucking deposition. These bitches have walked us in a circle. 6 good times. That's exactly what came to mind. He threw in a furthermore. He'd been watching. Mm-hmm. Mr. Hayden has not worked for Unite the People in approximately 6 weeks now. And there, as far as I'm aware, Unite the People was attempting to get a new attorney, but I'm not sure if they were able to secure a new counsel or not. So I am not privy as to whether they have anyone to represent any client at this point in time. The court. I'm not sure about this point in time, but what I can say is that at the point in time when this was at issue, he stated that he had no objection. Miss Dixon, and when was that, Your Honor? Mr. O'Sullivan, right, Miss Dixon. Hold on, the court. Let me see if I can pull up the email. Is this the one you just sent me, Malind? The clerk. Yes, it was the same one that I had sent Miss Morgan earlier this morning. Clerk threw shade. Not at all. Yeah, yes, definitely. Definitely. The court. Okay, let's see. Miss Morgan, what time was that? I'm sorry, I have so many emails. The court reads, it's come to my attention that Daystar has no lawyer to represent him. Let me first apologize for the late objection. Okay, so you sent Miss Morgan's email. I see attached, EFC number 65-1. Let's see. Okay, so that exhibit that's attached, Michael Passier, Miss Morgan. I believe he was the local Florida attorney, the court. Okay, Miss Morgan, yes. Oh, this is the we have nothing to do with Mr. Daystar Peterson. He is not our client. While Mr. Hayden represents him in state court criminal appeal in habeas California, blah, 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 blah. The court, April 11th. He's going through the chain of emails that were sent this morning or the morning of whenever this happened. So the judge, April 11th, okay, and that's where he says he will not oppose any action taken against him individually, Miss Morgan. But that isn't Mr. Peterson saying that. He doesn't object to the continuation. That's him saying that you can do what you wish to do against him, the court. Okay, so you're officially saying that you do represent him. You would be then the first attorney that is officially representing him. Miss Morgan, yes, Your Honor, I am. Yep. The court. Okay. All right. I just want to make sure you're on record. This is another bar. This is a courtroom version of a filibuster. Yes. Excellent. And you are available for the deposition on October 8th and October 15th, Miss Morgan. Yes. What other dates? I'm available. Let's see. The witness, Crystal, I don't think you should set any date until you guys file that injunction. Mr. O'Sullivan, we'd like to proceed today. Miss Morgan, that's why I'm saying October, so we'll have time for the injunction. The injunction will be very fast, Daystar. The witness, I mean the court. Miss Morgan, the dates that you're available, Miss Morgan, October 8, 9, 10, 13, 14, 15, 16, 17. I'm very lucky. I work for myself. You don't have any fucking clients. Miss Dixon, but Your Honor, the court. So any of those dates you would be available? Miss Morgan, yes, Your Honor, the court. Okay. Miss Dixon, Your Honor, I don't have my calendar though, and I'm a pretty busy criminal defense lawyer. So I do think I have something on October 8th, but I don't know about all those other dates. October 8th, I do have a motion. The court. Hopefully, you can have someone else sit in for you. Thank you. Miss Dixon, for this, I have a motion on the other matter, so I can't have anybody sit in for that. On that. On the October 8th, definitely I'm not available because I already know that I have two motions to argue. Miss Morgan. And I can defer to Miss Dixon's schedule as well. I'm an appellate attorney, so I don't have court as much as she does. The court. All right. So I think we've done all we can today. I will expect to get motions, I'm sure, from both sides on this matter. Nope. And we'll rule on them as quickly as possible so we can move forward to have this deposition done as early as possible. Mr. O'Sullivan. Okay, I'll just note my objection, Your Honor, on behalf of the client. The prison accommodated us, Everybody is here. We've incurred enormous expense. And obviously, we'll be making a motion. Mr. Peterson is subject to the jurisdiction of the federal court. He's not going to get an injunction against this deposition. It's going to happen. I would propose we just do it since we're here. The witness, I'll pay your flight. Don't worry. The court, all right, it will happen. Yes. Okay. Miss Dixon, thank you, Your Honor. Miss Morgan, thank you, Your Honor. The court, thank you, everyone. The witness, I'm good to go. It's just there are a bunch of people who didn't speak but are like on Zoom or on call-in. Thank you, thank you, thank you, Your Honor. The videographer. Okay, this concludes today's deposition of Daystar Peterson. The time is 11:07 a.m. and we're going off the record. So that is volume 2. They ended it at 11:07. It started at 10:23. It's almost an hour and a half of biscuit head bullshit. I don't have a date. I don't have a scheduling date for the deposition, period. We don't know what happened after this on that docket. There's nothing on. Let me check right now. There is nothing on the lawsuit docket, which is where this would come up after this day happened, where they took this deposition in relation to this deposition, other than he declined to answer any questions. Then Crystal Morgan filed a motion to quash or, get a protective order. They issued that in the Southern District, in the Central District of California, saying California has jurisdiction over Daystar Peterson. Florida does not. Florida has jurisdiction over this deposition. Period. That's been proven time and time again. Florida does have jurisdiction over this deposition. The judge made it clear repeatedly. And then at a certain point, he just said, you know what? If this is going to be how you do it, then this is going to be how you do it. There is not an update on the docket on this issue. I already gave this update during this live. This is where listening comprehension becomes an issue. What I literally just said out of my mouth was that there is not an update on the docket about this issue after this deposition was taken, except for that he did not participate in it. Then Daystar Peterson filed a motion in the Central District of California, reviewed it. Shit writing. Weak ass argument. We're reading all of these things because they were attached to Megan's objection to his bullshit motion in California, asserting that Florida does not have jurisdiction over him. Don't try and correct the host. Very simple. You weren't listening to the words out of my mouth, so it doesn't really matter if you just joined. What I said was, there's no update on this. You heard me say that. I'm talking about a deposition. You talked about pretrial notes. So it doesn't matter that you weren't here when I gave the update on pretrial scheduling. You just heard me say words out of my mouth, then tried to tell me there is a new update. Nope, not on what I said. So you heard me. You were here for the relevant part. Today ain't the motherfucking day. I get docket alerts for these cases directly to my veins. Literally, nobody who is familiar with this community is under the impression that I need to be told about updates about anything. But you heard the specificity of what I said and came in strong and wrong. So that's the end of that. Not going to discuss it anymore. You also don't get ahead of the host on this channel. So if you just got here and you don't know what has been discussed, you shouldn't be discussing something outside of the topic that is being discussed. This is a normal practice here. One way or another, coming or going, you're wrong. The end. Gavel. So now that we have looked at all this, we know that we don't need to look at volume 1 of the deposition because it's all coming back to me now. It's all coming back to me now. We did read it. He did act like a biscuit head and pretended to not know what words meant. Did affirm that Michael Hayden was his attorney. They made it very clear. We are here in the limited capacity to help him get through this deposition. Well, this is the same fucking one. Who's on first? Filibuster for an hour and a half of just utter bullshit. Just utter bullshit. And this is calendared over, Daystar's motion is calendared over like a 20-day period or something. I think if they don't get an answer from the judge on their response, or if the judge hasn't ruled within 24 hours, they might send a note to the court, or they might file a letter motion to the judge saying, we need your decision expedited on this based on the papers, which is what's on the docket. Rhonda sent me. Both of those women just acted like fucking idiots. It reminds me of Diddy's lawyer crying. The minstrelsy of it. You people is so racist. No, he's talking about manipulative ass lawyers. That's what the fuck he's talking about. I would have said the same fucking thing. You people want to play fucking dumb. O'Sullivan had it from as soon as he figured out, oh, these motherfuckers are in it together. Okay. Oh, you're going to play dumb too? Okay. It's absolutely nobody's fault why you don't know this shit. I didn't get this until Saturday. Okay. If there's one thing on the docket that you should have fucking figured out, well, it's so voluminous. Everything's labeled. If there's one fucking thing you should have figured out for this fucking deposition, it's at what point in time was there ever a ruling on jurisdiction? You could have traced one thing. You didn't have to go through everything on the fucking docket. You could have traced one thing on the docket. Show cause. You could have traced just that in a day and gotten all of the answers that you needed to come in prepared, to be prepared to look at your client and say, yeah, you got to answer these questions. But you didn't do that. That was a choice. And the amount of conversation that Daystar Peterson is having with Milagro-Graham's lawyer in the room, like he fucking knows her, was disorienting, to say the least. And her just, no jurisdiction, blah, 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 blah. Bitch, please. Bitch, please. You playing a whole ass fucking game. Ain't nobody interested in this bullshit. This is absolutely absurd behavior. Dixon worked for Daystar. Hello, beautiful. Welcome. I don't recognize your name, but you came in hot with a good one. Got my attention right away. I mean, the name Rhonda Dixon does feel hella fucking familiar. I wonder if that's why. I thought that I was just conflating it with somebody completely unrelated, but I never looked into her and I don't pay attention to Daystar. So I never did what I did with like Unite the People, which was like, where have I seen this name before? And went and compared it everywhere. I did not do that with her. Thank you for that. I appreciate it. Thank you both. Appreciate it very much. So yeah, I don't know and I'm not gonna look because I don't really care. I don't know exactly when this has been recalendared for, um, or if it's even gonna go ahead. Because here's the thing. Let's just say, for the sake of argument, okay? Let's just say for the sake of argument that it's calendar, he's not gonna participate in it until he gets a ruling from California because he's filed his thing in California. So even if it's on the calendar, he ain't gonna do shit, right? And it appears that they waited. Let me go back and look at the date of this deposition. I think it was on September 15th, if I recall correctly. Yeah, September 15th, 2025. When did they file their thingamabobber? They waited almost 10 days. She said during that deposition to Daystar Peterson, I'm gonna file it tonight. That was September 15th. They filed it on September 24th. So even after 15 days of looking at the record, she said, I don't, let's file it. This is biscuit head assery, period. No, I disagree with you 100% on that. This is not about his appeal at all. This is about him trying to fuck off Megan's trial, which starts next month. That's what all of them are trying to. They're trying to not give their depositions before trial because they think in their heads then that they're free and clear. Right? And I said this a little while ago with regard to this situation is that when you look at everything these people have done, and we've read damn near every single document here in the years since this case has been filed. When you look at the actions of these people, when you read their depositions, what becomes apparent is that they clearly feel like they are successfully keeping Megan from getting certain information, right? That's why they're not participating in the depositions. I'm this blanket for everybody who's not participating in depositions because we've looked at all of them. They clearly feel like they are being successful in some way with relation to her lawsuit against Milagro Grams. Like, well, if we don't do it, we don't hand it over, we don't blah, 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 she's not going to have the evidence that she needs when she goes to trial. The problem is, in doing that, they generate evidence. Picking up what I'm laying down? Their depositions as they stand are evidence under oath. They don't need to be called to testify. You're under oath when you give a deposition. So if under oath you have obstructed the process, and if there is a pattern of obstruction across specific people who are alleged to be a part of a broader network, guess what? Guess what they accomplished in this whole process? That's right. Creating evidence of coordinated obstruction. And that in and of itself is evidence. Nothing that he is going to be asked is going to jeopardize his appeal. He's going to have a judge there. He can't self-incriminate because a judge would stop him from doing that. So he's fully protected in doing a deposition with a judge present. For a judge to literally say to Megan's lawyers, you can't ask that question. But they also we don't have questions about that. He's found guilty. We don't have questions about the shooting. We have questions about everything around the shooting. So it's not about he's delaying for his appeal. His appeal is bullshit and gonna fail. But it's not about that. It is literally about obstruct her lawsuit so she doesn't have the evidence that she needs when she goes to trial. And of course, her attorneys are forcefully making the argument, as they should, legally. If she doesn't have this, she doesn't have what she needs to go to trial. They're obligated to say that in their argument. That's per case law. Nevertheless, the residual impact is they are generating evidence that fits her claims. Does that make sense? When you see how they talk to each other and about each other, they're throwing around, well, unite the people may have been, it was an issue of ineffective counsel. Huh? What? They all wind up eating themselves and each other. The way those two lawyers clicked up in that room so fucking fast, with attitude, I thought for sure the judge was going to tell Milagro Graham's lawyer to shut the fuck up because she was just ad-libbing in the background. No jurisdiction. The audacity. The fucking audacity. Well, good. I tried. Thank you. She already has a slew of shit. We went through the evidentiary list that she has for trial. It's over 400 pieces of evidence. She has expert witnesses and other witnesses to testify. Milagro hasn't deposed people. She hasn't properly served people. Then she's tried to compel people into depositions, and they're like, the fuck this got to do with me? And why are you asking me now? When'd you get sued? Last year? It's not going well on her side. So it's no surprise to me that her lawyer is like, yes, let me click up with Daystar Peterson's lawyer right now, because that in one way may help my client. It's not an end all be all. These people feel like they seem to think that they have possession of the Holy Grail. And if they can just, hide the rainbow row long enough or until the end of trial, then the Holy Grail is theirs. That's not how it's going to go. That's not how it's going to go. Megan has enough to win, as is. I think Megan also has enough to sue the shit out of everybody else in one fell swoop. But nevertheless, her attorneys are going to use every mechanism possible to get true and complete depositions from all of these people down to the very last day that it's possible for them to do that. And then they're going to take all of that shit and it is also going to become evidence. Some of it's already on the list. So, yeah. Yeah. They think they're fucking geniuses. They are fucking dumb. There's no other way to put it. Dumb, beloved. They're dumb. Okay? Where's my bucket of ice? Damn, I don't have it. I had an image that I made. That's technically oh, there it is. Dumber than a bucket of ice. They're seeking every kind of damage you can in the existing lawsuit. They're seeking every kind of damage you can imagine. This is a fucking bar. This sacred high five is for you and for all the other bars that have been dropped in this live chat so far. Y'all killing the game. I'm bulletproof. Why would anybody question it? Lawyers can hopscotch around all they want, right? And I don't think it's that big of a deal. It's not easy for these dumb motherfuckers to find lawyers. Did you see O'Sullivan or hear O'Sullivan, who is Megan's lawyer, almost lose his shit about 8 times during that deposition? Because these people are bad people. That's number 1. And number 2, bad people deserve legal representation. I'm always in here fighting for, everybody's civil and constitutional rights, right? Bad people deserve lawyers. You know what's really fucked up, though, as a lawyer to deal with, or as a strategist, or as an advocate, or anything like that? A bad client. It's a fucking headache. A bad client who's on biscuit headassery and is not coming in good faith. That shit's fucking annoying. Really fucking annoying. If you all haven't seen it yet, there's a new scripted video out about the podcast bros, including Aiden Ross, explaining the strategy of crying like a little bitch in October. It's a paraphrase of the title, but check it out. Give it some love when you get a chance. Share it around, get those likes and those comments in there. It's been a while for a scripted video, and I've had a rough day. I'm doing my best, Tom. I'm doing my fucking best. Every once in a while, I come up with those around here. I sure do. I sure do. I just don't feel like in good faith I can pass out anything but Rick Ross's titties, but I know that will traumatize the chat, so we just gonna go ahead and move on. We just gonna move the fuck on. Oh, yes, baby. We read the whole transcript. We read the in this live. So maybe you replay gang it if you want to, and you'll just be like, "What the fuck is going on? What the fuck is going on?" I've never read a transcript for a deposition where no questions have been asked. It's an hour and 30 minutes of one lawyer specifically about to lose his shit. A judge who's like, "You know what? Fuck it, go ahead. Play stupid games, win stupid prizes." And then Daystar Peterson's lawyer and Milagro Graham's lawyers deciding 2 biscuit heads are better than 1. Let's work together on this and see if we can confuse the court into weaseling out of this deposition. It was a filibuster. It was a, who's on first kind of shit. And it was outrageous. It was an insult to all of our intelligence and a waste of everybody's time. Not our time, but their time. And Daystar was in there talking big shit. Big ol' shit. Big shit. Don't worry. Excuse me, don't worry. Y'all are not gonna have to deal with Rick Ross's titties in this transition. I promise you that. I promise you that. Um, Princey is going to be donning a new costume this week. It will be unveiled at some point in time this week. But for those of you who missed it, okay, it's spooky season. This is my birthday month. It was also my late son's birthday yesterday. Like I said, it's just been a whirlwind of emotions and real world stress and anxiety that have taken me on a journey. But anyway, nevertheless, my favorite season, spooky season, my birthday month. And Princey, Princey's an old boy, but he has never properly celebrated Halloween. So the chat has been hooking my boy up, they've been hooking my boy up. So if you missed it, there he is. Thank you. Thank you. Thank you. It was really fucking irritating. Talk about how many lawyers does it take to screw in a fucking light bulb. Absurd behavior. But yes, behold. Uh-huh. Uh-huh. The Beehive mascot. You heard what I said. The Beehive mascot. Princey. My baby. Thank you. I appreciate it. Thank you. I appreciate it. It's just so adorable. So, yes, this week he's going to be a pumpkin. Okay. I thought about doing it yesterday, but yesterday I was just like, I started off at the highest of highs and then fell down to the lowest of lows and then kind of, found a low mid range of survival. And then today has just been a lot of shit. So I've looked at this picture a couple times just to warm my heart. I need to be in the right, you can't be thinking about and then putting your cat in a costume. You have to be really present so that you can really enjoy it. Because you might not get him back in it after you take it off. We got to, be set up for the photo shoot and all that stuff. So, yes, this week he will be a pumpkin, but last week he was a bee. And it was adorable. It was adorable. Thank you. No, he does not particularly like it. However, when I put him in this costume, he immediately demurred. He just kind of just like rolled onto his side and just stared at me with purry, lovey eyes, made biscuits, and was like, "Do your worst with me. Do your worst." I put it on him. He was like, "Oh, okay. All right. This isn't too bad." And then he got off the couch and the waddle that his butt gave, I was like, "Boy, you gonna throw your back out. You gonna throw your back out." He did a whole strut, the whole catwalk, no pun. Did a whole strut, one way, then the other, and came back. I gave him good lovin's, good treatsies, good positive reinforcement. He tried it with the hoodie down, tried it with the hoodie up. Didn't really let me know what he, decided. Do you like it this way? Do you like it that way? I did, if you're wondering, show him himself in a mirror. Didn't get any real particular, response. But yes, and at no point I was not injured in the process of putting on said costume, which I was concerned because there's no zipper. Yeah, it's got to go actual hoodie style. Yeah, Pete's and all. Yeah. So, but he was very, very, very agreeable, and pretty much every costume after this is a breeze. So I know it's stupid. It is stupid. I've literally had people tell me in, hostile professional exchanges that I am a heartless bitch. And I have literally responded with, "You are wrong. I have cats and they love me." So, mhm, mhm. But my white woman tears. Yeah, I don't give a shit about that. You heartless bitch. Oh, I thought you were crying. Now I'm a heartless bitch. My kitty proves this is not true. My kitty proves this is not true. Cats don't like bad people. They don't like them. They don't like them. You ever listen to a animal communicator talk about their conversations with cats? These arrogant motherfuckers really do think they are gods. So the last thing that they're gonna put up with is a subhuman human, with a bad fucking attitude. No, no, they're not doing that. So yeah, it is spooky season, my favorite season. My birthday season, I'm an old lady season. I'm still here. Is all I can say. I'm still here. That is the wrong thing. Um if you would like to contribute to spooky season, first and foremost, hit a direct contribution to the docket fund. That's always super appreciated. But that link that I just put in there has all the links. Okay. There were some people who were like, you need to pick a restaurant that we can get gift cards at. So there's a link there for that. There's the gift list, which has things for the kiddies on it as well. That's where see that back there? See that right there? That was another one. I've got a couple that I haven't opened. So if you're sitting there like, well, I got you something, you haven't said anything yet. I'm not doing it on this live. I'm not even formally doing a thank you for the Cowboy Carter absolutely deluxe album with the book. Bitch with the book. This isn't even an official thank you for that. Just like I was like, I'm not putting Princey in this costume. I was like, I'm not opening these gifts when I'm dealing with this other shit. So I haven't opened them yet, but I do have them. Thank you very much. I appreciate you. Appreciate you. But yeah, all the links are there if you're so inclined. I told you. I told you it's wild. The pet psychic rabbit hole is wild. You are trouble, and I like it. Let me tell you something. You hitting them links and them gift cards. That is the ABSA After Dark. You know, that is the ABSA After Dark list. Straight up. Massive, huge, massive. Somebody, I haven't opened it yet, but I know because I got a notification that it was purchased. Somebody got me John Williams in Tokyo. I'm very excited for that. And then I did not know, but I put it on the list. And if somebody gets it for me, I will be eternally grateful. If nobody doesn't, hey, that's fine. At some point in time, in maybe 2026, I'll cop it for myself. But I had no idea. John Williams is one of my favorite composers ever. Yo-Yo Ma is one of my favorite artists ever. And as I was perusing, classical albums as one does, I saw a John Williams and Yo-Yo Ma live album. And the giddy little shrill sound that I made when I saw that, I thought I had at least seen, not necessarily owned, but at least seen every Yo-Yo Ma thing that he's been a part of. Um, but I don't recall ever seeing that before. So yeah, I put that one on the list. I put some gaming gift cards on there. I put some lunch gift cards on there. If you want to buy me some lunch, you can buy me a lunch gift card. If you want to pay for my coffee for a month, you can buy me a whatchamacallit, Instacart gift card, because that's how I pay for my coffee. They don't have anything smaller than the size of the card that I put on there. So people are like, well, there's a lot of shit on here. There's 18,000 people and then some that are, subscribed to this channel, and thousands upon people who watch it. So if you're looking at it and you're like, why are there so many lunch, gift cards? Because if I just put one of everything, it's a rapid do. And then people be asking me like, I didn't get you anything. Just for the record, this did all start because of the chat of people being like, I want to get you something for this, or I want to get you something for that. It was before the 1 year that it came up, but it was at the 1 year where I very first did it. I did a gift list. There's always been something for the cats because these motherfuckers are expensive. And only one of them is technically mine, but I feed all of them anyway. And you all do too. And I appreciate that very motherfucking much. Take care, YouTube Unfolded. Man, I'm a huge. Oh, his music is it's just such a compelling performer. And he knows that cello. I mean, it really is an extension of his body. Truly incredible. Incredible. I'm so curious that one day, chat, maybe when we have a little bit of coin, we will, retain the services of a renowned and respected pet psychic. Some of them prefer to be called animal communicator. So, pet psychic slash animal communicator to talk to all these fucking cats. All these cats. That's one session, we just want to know what the cats have to say. And then a separate session, we want to know what devil and demon have to say too. I'm super curious. It might be traumatic for us as adults to learn about it, but I want to know. But I want to pay the docket bill first. Yeah, per as usual. That shit is stressing me out. Oh man, this is really hard. No. This is too difficult. This is too difficult. Every film composition is a banger. And I said a banger. I listen to them. Period. They're in my rotation. Period. And same with my kid. It should just be noted. One of my kids, who's 25 years old, is a huge John Williams fan. And the last time I had a little bit of money, I was going to not be living here where I live right now. Which would have changed my living costs, likely reduced them at least $50 or something. But anyway, empty nester, et cetera, living in a different place. And we were going to go. I can't remember if it was, I honestly can't remember if it was in DC at the Kennedy Center or if it was in New York. But John Williams on his 100th, I tried to get tickets to that and I couldn't get tickets. If I hadn't gotten tickets to that, I would have taken him to that for his birthday. But I couldn't get tickets. So that's how deep of fans that we are, that I was going to pay for us to travel across the country and pay for hotel and food and vehicles and whatever to see that in person. But that shit sold out so fucking fast. There was no way. There was no way. So I had to let it go. But no, I couldn't pick. I couldn't pick a favorite. I just think that all of his music is beautiful. I love it all. I even have some composition books, even though I don't particularly play those exact instruments. I feel like John Williams' music is truly a pop culture archive that spans so long that part of it is just, it was a part of my parents' history. It's become a part of my history. It's a part of my children's history. It's part of cinema history. It's a part of all these things. And it's a unparalleled legacy and body of work that, again, we have a multi-generational appreciation for movies and art in my family. So the music that my parents listened to growing up, I listened to growing up, along with what was contemporary growing up. My kids listened to what my parents listened to growing up, along with what was contemporary when I was growing up, along with what was contemporary when they were growing up. And you can repeat that in books, television, and movies. I watched the movies that my parents watched, along with contemporary movies. My kids watched what my parents watched, what I watched, and then what was coming out when they were coming up. Yeah, we have a deep appreciation for that. That shit slaps. Fight with your mama. That shit slaps. It's just ridiculous. It's so emotive. It's so good. And it's I don't know if I can there's like a word that's hiding on the edges of my brain. But it's like a time capsule and it's like a universe in music. You can put on any John Williams composition and you're there. And that's it. Same with the other guy. I can't think of his name. Interstellar. That wasn't Williams. That was what's his name? I can see his face. But yeah, we love all the classical music. Yeah, yeah. So yes, y'all. Yes, y'all. That is the update. That's not what I clicked on. Okay, I already looked at that. I do expect there to be either a ruling or some kind of time-sensitive action from the California judge. Definitely this week. If not today or tomorrow. I think it's going to come pretty quick. If it is as cut and dry as they have so forcefully argued. And now, having read their objection, which was the first thing that we read before we looked at the deposition, having read the deposition after reading their objection, the objection is just stronger to me, because in the deposition you've got a judge who's like, oh, we're going around this again. Okay. You want me to explain it to you again? Okay. You want me to pull documents off the docket to show you again? Okay. You've got the judge telling them, you're going to wind up back here right in front of me doing this shit again. This deposition is going to happen. That's why he said you don't just get to walk. Pick a day. Pick a day. So if it is calendared for tomorrow and they walk into it and pull the same shit because they haven't gotten a ruling from California, then the judge is just going to calendar it again, or he's going to compel them to do it because the judge will have also had more time to go through things with a finite comb and be like, give me your best. Nope, we're doing this today. I'm not hearing any other objection. But yes, I think it will be relatively quick. Yes, it was Hans Zimmer. Thank you so much. Yeah, Interstellar is one of my all-time favorites. I had a full, fascinating experience listening to that soundtrack at top speed, driving through a empty off-season Joshua Tree, the long route, the truck route instead of the sightseer route. I had a whole experience. I thought I was going to get, it literally felt like I was being sucked into the earth. That's how hard Joshua Tree pulled me down and rooted me in my lower chakras. It was crazy. I was like, I've literally never experienced anything like this before. It was really beautiful. Really, really beautiful experience. That would be Ludwig. Yeah, I've talked about him before. That dude be on that mojo. He be on that mojo with indigenous sound. It's crazy, but really beautiful and deeply appreciated. Deeply appreciated. Yeah, he's incredibly talented and patient and nurturing when it comes to music. This is his life's passion. So I just love the fact that they actually connected with each other in film school and became friends before anything else. I love that about their relationship. I really do. I think that's special and precious, and they're going to continue to create beautiful art together for our lives. And we are lucky, just like with his DP and other people that he works with. We're very lucky. Spike did the same thing, except for his last movie was fucking ass. But we're not going to get into it because I've already ranted about it. I've already done my little rant about it. In the waning moments of this live, is there anything that's happening right now in the news that anybody wants to get a quick reaction from me about? Bueller? Anybody? Um, the Mark Sanchez situation has me very happy. I just have to say. Fuck MAGA Mark. Period. I hope he loses his job and gets the help he so clearly needs. What else? Shador Sanders not playing quarterback is bullshit. And I saw a bunch of people on social media this morning saying, well, the quarterback for the Raiders is ass. Maybe. I don't know, maybe. The Raiders take Shador. I said, baby, put it in my veins. Pete Carroll getting some Shador Sanders? Fuck yes. Please and thank you. I haven't seen it, so I can't comment on it. I'll have to look into it. Not surprised. Not surprised. Not surprised. I also saw, and I haven't dug into it yet, but I'm gonna because I just can't believe this dude is 17. Every time he opens his mouth, I'm like, I can't believe this dude is 17 years old. I can't remember his name, and I can't remember where in the United States this has happened. Sorry. Nevertheless, there is a situation where a streamer killed 2 high school students on purpose, it would appear, at least alleged by law enforcement, ran into them at 70 miles an hour with his SUV, hated one of the girls, had been stalking her for some time, did a live right after he killed her, then did another live a little bit later. But he has said horrible things about this girl and tormented her and her entire family and been very public about it. He has video upon video upon video archived lives where he's talking about this girl, and apparently he saw his opportunity and he took it. But again, I just get jarred every time they show him because he is 17 years old and he looks like he's 25. He sounds like he's 25. I'm like, what the fuck? And he's so clearly he was so here's the thing that the news isn't saying about the situation is his beef with this girl is related to a lot of things. First of all, likely her not paying him dust. But also, and so then he started stalking and harassing and all of that. Apparently, he sent some inappropriate content, was reported for sending inappropriate content that allegedly showed underage people. So there is that. And then she, at some point in time, expressed her fuck that dude with regards to Charlie Kirk, and he was a massive Charlie Kirk fan. And people who watch him say that really bothered him. But the fact that he went after that, went and sat down and talked about it as if he didn't know he had done it, and then said, I'm a good person. I come from a good home. I'm only 17 years old. I come from a good family. They stand behind me, and she should take back what she said. She should do this, that, and the other. I was watching that like he's psychotic. I believe it was in New Jersey. I believe it was in New Jersey now that I'm thinking about it, because I just flashed to newjersey.com, I believe, was a website where I was seeing a bunch of reporting. Um is all I can say. I don't even know. I don't even know. That's devastating. Really, truly devastating. And the his righteous indignation is something to behold. His righteous indignation over the whole thing is something to behold, for sure. Yeah, the problem is crimes aren't jokes, you know? And that's what a lot of these white people don't understand, period. A lot of white people don't understand because white people intention is they think because they're treated by society that it could be. But white people think intention is the armor to everything. I was just joking, you broke the law. It ceased to be a joke. But I was just joking. This isn't about intention, it's about impact. White people hate that shit. And these young white people really don't fucking get it. You can see it every time there is a video of a young white person or an older white person in a fucking confrontation with law enforcement, and they are doing everything but getting shot. Pushing on officers, in officers' faces, walking away from officers, throwing things at officers, refusing to be arrested. White people just refusing to be arrested by the police. Okay, so Megan has filed something else. On the Daystar Peterson docket. Give me a second. This is the motion to expedite. As I said, if this isn't something that's super, super fast, it would not surprise me if we see Megan's lawyers come back onto the docket and tell the judge, we need this expedited. So yes, they have filed a motion to expedite the hearing on Daystar Peterson's motion for protective order. Because apparently it was set for a hearing. Was that before or after their entry? I'm not sure. Let me just look and see. Go back to the docket. At least in what I'm looking at right now. Motion was filed. It was assigned to the judge. The judge set the schedule. Summons issued. Objection. And then, yeah. Expedite, please. We already looked at that document. No, we didn't look at that document, but we don't need to. That's just email communication that they've already alluded to, which is that Daystar Peterson's attorney refused to meet and confer. They attempted to reach out to meet and confer on this and just gotta we don't agree. Oh wow. They want this hearing in less than 24 hours. They want the hearing to be tomorrow at 11 a.m. We'll see. Oh, what happens? So, take care, Goldie. I didn't say white people were animals. At least not in this live. I don't think I've ever fixed my face to say white people are animals. I'll say a lot of things about white people as a group of people, which is that they are inhumane. They are ignorant as shit. They are arrogant as shit. And they think the rules don't apply to them until they fuck around and find out that they do. And they're not temporarily acting up. They've been acting up. I don't feel like recounting 800 years of history, though, to prove my point. I know you see it. I know you get it. They gonna continue to act up. That's what white supremacy does. It acts the fuck up. I think his hearing is at 10. I'm not sure, but Megan has a bevy, okay? A stable, a harem of attorneys, if you will, a roster, okay, of attorneys. So they will figure it out. They'll just split it between them. One of them will be over here. The other one will be over here. But yes, tomorrow, Livingston Allen has been ordered to appear in court. Nom, 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 nom. It's delicious. I love it. My favorite thing. Mhm, mhm. So, yes, that is that on that. I appreciate y'all for hanging with me, and catching the update, liking the live. Shout out to the replay gang. Sorry that we missed you, but good to have you in the comments section. I'm sure I will see you all again soon. I hope you have a wonderful rest of your day and a good evening. Eat something good. Okay. Take take good care of yourselves today, because sometimes that's all we can do. See you soon. Peace.